offender in the predicate offense. That is the crime number 12 of 2024. Well, when I made that submission, my learned friend submitted to your lordship that under section 50, he could record the statement of anybody. Undoubtedly, well, they have the powers. May I just request your lordship to kindly turn to one of the documents which I have produced at ink page 32, which is an annexure to the notice issued under section 50. In my petition, 1121.
1129.
1121.
21.
1129.
29, correct.
I'm sorry.
Yeah,
I stand myself corrected.
Yes, sir.
Can you go to page 32 minutes for a second?
I'm there.
I can understand these things, personal profile, for a witness, identification marks and all that, website address, telephone, residential, business.
Pro forma ide 32 ಅಲ್ಲಿ pro forma ಇದೆ. General information.
General information questionnaire. ಅದನ್ನೇ ಕೊಟ್ಟಿರೋದು ನನಗೆ ಇದಕ್ಕೆಲ್ಲ ಉತ್ತರ ಹೇಳು ಅಂತಂದ್ಬಿಟ್ಟು ಅಂತ.
ಉತ್ತರ ಹೇಳಕ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಉತ್ತರ ಹೇಳು ಅಂತಂದ್ಬಿಟ್ಟು ಅಂತ. ಏನಂದ್ರೆ
ಪಾಸ್ಪೋರ್ಟ್ ಡೀಟೇಲ್ಸ್.
ನಮ್ಮ ಅಪ್ಪಂದು, ನಮ್ಮ ಅಮ್ಮಂದು, no, it will not stop there. My father, my mother, my grandfather, my great grandfather, my children, my grandchildren, my relations. Why? Are they not making an inroad into my privacy, my lord?
Brother-in-law, sister-in-law, brothers-in-law.
ಎಲ್ಲರೂ ಇದ್ದಾರೆ. ಅವ್ರ ಬ್ಯಾಂಕ್ ಅಕೌಂಟ್, ಅವ್ರ ಡೀಟೇಲ್ಸ್, my associates, my business establishments. Will it be in or in relation to the crime which they are investigating? But I assume office as a minister during the middle of June 2023. Well, it relates to the illegal or unauthorized allotment of 14 sites. I had nothing to do with.
You are what minister?
No, Mala, presently. I am a minister for urban development and urban water and drainage board. I assumed office in June, middle of June 2023. I think I need not submit to your lordship the facts of the case because your lordship
that I know.
Yes. The proceeds of crime, the proceeds of crime, my lord, is in or in relation to the illegal or unauthorized allotment of 14 sites, excepting that nothing else. Nane. In what way I am connected with that? But even the MD, Natesh, who is said to have been the person who has actually did this allotment, a notice came to be issued to him, and this honorable court would quash the notice issued to him under section 50 while permitting him to initiate action against the officials of Enforcement Directorate.
Where is that order?
Yes, my lord. May I request your lordship to kindly turn to
in the compilation that has been given, the first judgment, my lords, in that compilation.
Internal page, judgment page.
This was also against an accused?
I'm sorry, my lord.
This was against...
No, he was not, like me, my lord, he was not even an accused. But he held the office as the managing director during the relevant period. I never held any such office in Muda. Well, I come into picture to this department for the first time in my life, only during June 2023, and not earlier to that date. That is not in dispute. If that is in dispute, my lord, I can certainly place before your lordship on record the oath of office I took on being administered to me by the governor, His Excellency, the Governor of Karnataka, in June 2023. What did I do? Let them come out. I have absolutely nothing to do with this. Have a look at the questionnaire. It certainly makes an inroad into my privacy. I may not protect it under the Constitution, my lord.
No, is this questionnaire not considered by the Apex Court in Vijay Madan Lal Chaudhary?
No, my lord. For the first
this
time,
kind of a
no,
questionnaire?
No, for the first time, my lord, they are doing all these things.
ಅಲ್ಲ ಫಾರ್ಮ್ಯಾಟ್ ಫಸ್ಟ್ ಟೈಮ್ ಈ ತರ ಬಂದಿಲ್ಲ ಇಲ್ಲ ಅವ್ರ ಫಾರ್ಮ್ಯಾಟ್
ಇಲ್ಲ ಇಲ್ಲ ಅವಾಗ ಇರ್ಲಿಲ್ಲ
ಈಗಿರೋದು
ಈಗ
ಆಲ್ ರೈಟ್ ಎಸ್
ನಂದಿಷ್ಟೇ ನಂದೇನಾದ್ರು ಪಾತ್ರ ಇದ್ರೆ ಹೇಳಿ my lord I think it would be useful for me to invite my lord's kind attention before my learned friend Mr. Sandesh makes his submissions because he was the one who argued this matter before the coordinate bench.
Which one, Natesh?
Yes.
Rise, all right.
Arvind Kamath avare madidru alli, enforcement director.
ಅದು ಹೇಳಿದ್ರು ಅವರು.
And
I accepted that day when granting an interim order. Yes, there is an order against us.
ಹೌದು. ಇದರಲ್ಲಿ ಬರೀತಾರೆ ಇದರಲ್ಲಿ. May I request your lordship to kindly have a cursory look at. Kindly go to page 35, my lord, for a second. As far as I am concerned, I am only confining my submissions to the petition.
Only as far as you are concerned.
1129. Though on certain important and serious legal issues, I am sailing with my learned friend, Mr. Sandesh. Have a look at paragraph 25, my lord, for a second.
25.
In that spiral binding, my lord, your lordship has.
Spiral bind only, page 35, my lords. Natesh judgment, page 35, paragraph 25.
His lordship would refer to almost all the judgments on the point in issue. Para 25, internal page 35 of the judgment. His lordship would refer to the entire gamut of the case law on the point till 2024. Para 25, my lord. Similarly, in the present case, the alleged predicate offence pertains to the illegal allotment of sites during the petitioner's tenure as the commissioner of MODA. But I'm sure your lordship would certainly agree with me. If my lord is persuaded to accept my submission, that I am placed in a better position. Because I assume office only during June 2023, certainly not earlier to that date. However, there is no evidence to demonstrate that any consideration passed in relation to the conveyance or relinquishment of such sites was received by the petitioner. Consequently, the petitioner cannot be attributed any role in possessing, concealing, or using the proceeds of crime to constitute an offence under section 3 of the PMLA 2002. Furthermore, mere possession of a site that was allegedly illegally allotted to an accused in connection with a scheduled offence does not by itself constitute an offence under the Prevention of Money Laundering 2002, unless the essential ingredients of the offence as defined under section 3 of the Act are satisfied. In the light of the above precedents, it can be concluded that the existence of reason to believe as required under the Prevention of Money Laundering Act 2002 mandates the presence of sufficient cause to indicate the commission of the offence of money laundering. Additionally, it necessitates a corresponding justification for the seizure. That was in relation to that particular petitioner. Seizure of any records or proceeds of crime discovered during the search. Such a requirement ensures that the said property is not disappeared, layered, or integrated in a manner that renders it seemingly legitimate. To satisfy this threshold, the authorized officer must demonstrate that they arrived at an informed and objective conclusion based on credible material in their possession, that the proceeds of crime or documents related to money laundering are likely to be located at the premises sought to be searched. This procedural safeguard affords the principle of fairness and legality, ensuring that the exercise of power under section 17 of the PMLA is neither arbitrary nor speculative. A review of the recorded reason to believe, my lord may kindly note this, a review of the recorded reason to believe must show that the material available with the director is sufficient to support the conclusion reached. These conclusions must be based on reasonable evidence and logical reasoning, not merely a suspicion. For possession of proceeds of crime, the reason to believe must specifically show that the person being searched and control over and intend to use or manage the proceeds of crime. Simply holding the proceeds by chance or accident does not mean the person was involved in generating or hiding them as a part of money laundering. There must be a clear evidence of control or intent over the property to meet the requirements of the Prevention of Money Laundering Act. This ensures the law is applied fairly and prevents arbitrary actions. The learned ASG contends that where the criminal activity in the predicate offence pertains to illegal allotment of 14 sites by MODA during the tenure of the petitioner, the Lord may kindly mark this, during the tenure of the petitioner. My tenure commences only from June 2023. I am repeatedly submitting to your lordship, not prior to June 2023 at all. I was an utter stranger to MODA or even to the state. other than holding an office as a legislator. Beyond that, nothing more and nothing less. Petitioner as its commissioner, the said sites/properties as such satisfy the definition of proceeds of crime under section 2U of the PMLA. Therefore, where the allotted sites are the proceeds, the process of allotment presided over by the commissioner constitutes assisting a process of activity connected with the proceeds of crime, and hence constitute a reasonable cause for the purpose of conduct of search and seizure under section 17 of the Act. The law nowadays clarifies that the petitioner at this stage of investigation is not an accused, and that the impugned search was conducted on the basis of the reasonable belief that the petitioner, as the former commissioner of MUDA, may be in possession of the proceeds of crime or any records related to money laundering. Then finally, my lord, kindly go to para 35, my lord, at page 39. The petitioner herein further challenges the repeated issuance of summons under section 50 of the PMLA, arguing that these summons are vague because they do not specify whether the petitioner is being treated as an accused or as a witness. This, according to the petitioner, violates the constitutional protection against self-incrimination under Article 20, subclause 3 of the
Supreme Court has considered this issue. It does not amount to self-incrimination, is what is said. Supreme Court has considered
It has.
Yes.
Section 50 of the PMLA deals with powers of authorities regarding summons, production of documents, and to give evidence, etc. And the relevant portions thereof reads thus. His Lordship would quote, my lord, section 50. Then go to para 37. In the case of Vijay Madan Lal, the Honorable Supreme Court has clarified that the process under section 50 of the PMLA, which involves summoning a person whose presence is needed for gathering evidence or record, is part of an inquiry into the proceeds of crime and not an investigation to the prosecution under the Act. There is no doubt about this legal proposition. There is no formal accusation brought against the summoned individual at this stage to warrant invoking the constitutional guarantee under Article 23. In the case of Abhishek, etc., his Lordship would refer to any number of judgments on the point, commencing from that paragraph till the end, my lord, that is paragraph 53, his Lordship would refer to it. Then, my lord, in paragraph 54, thus, in the light of circumstances of this case, where no prima facie case has been established showing that an offense has been committed under the PMLA and no incriminating material has been elicited at the time of search and seizure, the issuance of summons to the petitioner lacks legal authority. The petitioner cannot be compelled to appear and record the statements or produce documents, as such actions would unjustified, infringe upon the personal right to liberty. Then, my lord, in paragraph 57, kindly go to paragraph 57, this is what his Lordship would say. Finally, as against the submission of the Learned ASG, that the instant petition suppresses the material facts of the petitioner and the scope of responsibilities incumbent upon him in relation to holding the office of the Commissioner of MUDA in the past, it is to be observed that the petitioner is not an accused in the predicate offense, and that unless the petitioner were to be informed that the investigation conducted is in relation to the particular predicate offense under the impugned search and seizure, etc., my lord, his Lordship would quote it. And finally, my lord, his Lordship would give him the right or the liberty to launch or take necessary action against the officials of the ED. That your Lordship would get, my lord, at page 53, Roman 5. Liberty is reserved.
Doing the word search and seizure.
Search and seizure was held to be illegal, that too by an unauthorized person, and the statement recorded is ordered to be quashed. In summons issued under section 50 also ordered to be quashed. And then, my lord, in Roman 5, his Lordship would say, liberty is reserved with the petitioner to initiate action under section 62 of the PMLA against the officer concerned before the appropriate forum, as whether the impugned search and seizure is vexatious or not is a matter of trial.
Question.
The role, and if my lord permits me to take your Lordship, the basis, the foundational aspect is the private complaint. Well, in the private complaint, not even a remote reference has been made to the petition before your Lordship in this petition. Not even a remote reference. But certain incidents is said to have taken place between 1990 and prior to 2023. Nowhere reference has been made to this petitioner. They could not have made any reference because I was not in the picture at all. Now, what is the purpose or object of they issuing me a notice under section 50?
So is it because you're the urban development minister today?
Looks to me.
Is that the reason?
Obviously, my lord.
Allah, is that the reason for issuance of summons?
Obviously. No. They must tell us why. Well, it is for them to say what sin or wrong I have committed. How am I connected to this crime? Is there a single solitary allegation or a remote reference to me in the complaint which came to be filed and which is the basis of the foundational aspect of the issue in question? Crime number 12. That your lordship would get. Kindly go to page 40 for a second, man.
Crime number 12, yavadu?
I'm sorry, 11. I'm sorry, 11. I'm sorry.
ಅದಕ್ಕೆ ಬರ್ದು ನಮಗೆ
ಅಲ್ಲ 11 ನಲ್ಲಿ ಇದು ಏನಾಗುತ್ತೆ
ಇನ್ಯಾವ್ದಾಗಿದೆ ಅಂತ.
ಹೌದೌದು, ಇದು ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ ಕೈಂಡ್ಲಿ ಗೋ ಟು ಪೇಜ್ 41.